Hello everyone, my name is Andres Martinez.
And I am Mayra Flores. We are student physical therapists, and today we're going to present a case we titled To Save or Not to Save. It is based from a Forbes article discussing an ethical dilemma presented to all healthcare professions. Additionally, we will speak of what governing bodies suggest the correct action in this scenario would be, and what future steps you can take to avoid a situation like this in your practice.
We'll begin by giving a brief background of the article. The article is from 2013. There was a nurse working at a facility in California and was confronted with the situation where she had a resident from her senior assisted living home who collapsed, and she was faced with a dilemma in that she couldn't provide CPR to that particular resident according to her facility's protocol. So she got on the phone with, she called 911, and the operator asked if there was anyone capable of performing CPR on the person until the ambulance arrived, to which the nurse responded that she could not do that according to the policies. The operator, according to the article, sounded a little shocked because she didn't think it was okay for her not to perform CPR, but the nurse was genuinely conflicted on whether or not she should perform the CPR, because if not, she would break her facility's protocol.
So this raises a question: should human decency stand above policy? Should the nurse have been able to perform CPR despite her employer's policies? It can be argued that many ethical principles were tested in this situation, including the four core healthcare principles, which are autonomy, justice, non-maleficence, and beneficence. Essentially, in this scenario, the principles most directly affected are beneficence and non-maleficence. As a reminder, beneficence is described as healthcare providers doing all they can to benefit the patient in any situation, while non-maleficence is described as to do no harm. The nurse disregarded the beneficence of the patient and did the opposite of non-maleficence when she opted to not perform CPR on the patient.
Additionally, it can be argued that some of the APTA core values that our profession has laid out for us were tested as well. Altruism, which is defined by the APTA as the primary regard for or devotion to the interests of patients, clients, thus assuming the fiduciary responsibility of placing the needs of patient-client ahead of the physical therapist's self-interest. You could say that it was not demonstrated by the nurse when she put her self-interest of not getting fired potentially before the patient's needs. We also believe that professional duty was challenged in the situations, since the nurse or PT, in our case, would not have been able to provide optimal care for the patient.
So with these principles and core values under distress, one should question why the provider did not act in the best interest of the patient. Was she afraid of possibly losing her job as a result of her breaking policy? At the time of the incident, the only law that could have possibly allowed to perform against company policy was the Good Samaritan law. However, in the state of California, the Good Samaritan law only would have protected the provider from civil litigation. However, it would not have protected her for the possible termination. However, California has since passed a new law, Assembly Bill 633, prohibiting employers from setting or enforcing policies that prohibit employees from performing CPR or other emergency medical services, except in cases where the patient has an advance directive or DNR.
A principal method to avoid situations and dilemmas like this are just to make sure that the facility that you work at has the patient's advance directive, if they have one. I think this clearly shows that everyone should have an advance directive. In this particular case, we see how the nurses didn't have an advance directive to base their decision off, and so ultimately you don't know the patient's desires. An ethical dilemma could have been avoided if an advance directive had been given. Additionally, if you see yourself having a clinic in the future, it would be great to have all healthcare personnel know what the advance directive is and to just consider what you would deem necessary to provide the best care for the patients that you are going to be seeing.
In addition to that, making sure that you know the laws revolving around these topics within the state that you're practicing is important. For example, the Good Samaritan law varies by state. Therefore, in Texas, since we live here, it would be good to know that there are specific exceptions to who is covered by the Good Samaritan law.
And here are references. That's our presentation. We thank you for your time and we hope you enjoyed it.
Thank you.